is Clare Cudmore. I'm the Executive Legal Officer for Court Administration at the Nunavut Court of Justice. My job is basically, in a nutshell, to provide legal advice and support to court administration. But I will put a warning in advance. I have a deep and abiding, acknowledged, very nerdy love of civil procedure. So I am here out of personal joy and hope to share some of that joy with the people that are attending the session. And I am once again very excited at the number of people that were interested and really happy to see all of you guys here today. So this session, and I apologize in advance, there might be some a little bit of fumbling. I can't actually see you guys because I have to use the desktop client of Zoom, which is unfortunate. So if you have questions, please feel free to just jump in. But so this course today is really focused on the form requirements of the rules of the Nunavut Court of Justice. And so the first thing that we're going to talk about is why civil procedure is important. So civil procedure is important for a lot of reasons that I think it's a really great reminder to have a refresher discussion about. Civil procedure, when I try to have a plain language discussion with clients about how the court process starts, one of the things that I always say is, regardless of why you're accessing the court, every single court file starts with a piece of paper. And with the civil law, that piece of paper is guided by the rules of court. And so the paperwork that we do as lawyers to bring matters before the court is, in a literal sense, how our clients access justice. And so doing that correctly and knowing how to do that under the rules of court is extremely important. Also, there are some professional liability reasons that we all as counsel need to keep in mind. And I did take a moment to pull together just like a case that has happened here in Nunavut. There are times when ineffective civil procedure practice creates liability for us as lawyers. And I will read a section from a decision of the Nunavut Court of Justice that says, lawyers have an ethical and professional duty to ensure that the advice they give a client and the actions they take are proper. In other words, every lawyer has a duty to present the case for their client in good faith and according to the rules of court and the applicable law. In this case, the laws of evidence. An affidavit may be sworn evidence of the client, but it is the lawyer's duty to ensure that the affidavit is drafted and submitted according to the rules. In Canada, a lawyer who fails in this basic duty runs the risk that costs shall be imposed against him or her. And this was a case that happened in 2016, where the court was actually considering, and I believe did impose, costs against the solicitor personally for deficiencies in a document that was filed in civil proceeding. And for those of you who may not be familiar with the case and wish to read it, the citation for the case is 2016 NCJ 23. And you'll see that that case has actually been cited if you use the really awesome treatment tab that's available on Canly. You'll see that that case has actually been referenced in other decisions, and that case goes through and references a number of other cases where courts have considered the actions of lawyers in relation to civil procedure. And so I always like to remind people that that's a reality that we all face as lawyers. Other issue is that written advocacy, the paperwork that we prepare as lawyers, the documents you are filing with the court, are really a part of effective advocacy. You can really effectively advocate for a client in a really impressive way by having a foundational understanding of the civil rules. It also ensures timely access to the court. The rules contain a real roadmap for how procedure happens in the court. And your ability to access court in a timely fashion is impacted in two ways. One, because as we know, the rules have particular timelines for taking actions in court. But also, if you are engaged in an exercise where you keep having documents rejected or marked as deficient, that can actually, in a very literal sense, delay your ability to proceed with your matter before the court. I also like to flag that there are competency requirements in our Code of Professional Conduct. Part 3.1 talks about the competence that we are required to have as lawyers. You are presumed to be competent in the work that you are doing, and that includes civil procedure. The quality of service requirements under the professional conduct rules also include that you will provide quality service to the client and quality of advocacy. And not to be forgotten, the first impression that you make with the court in your advocacy is the originating document that you file in civil matters. It's quite literally the first thing the court may see. And so believe me, the court reviews the documents that you file and sometimes gathers impressions of you as an advocate based on the quality of your filings with the court. So all things to keep in mind and percolate on about why civil procedure is an ongoing responsibility and important consideration for counsel that are advocating. But I will point out that civil procedure is a beautiful rabbit hole. And we could easily fall down that hole in the course of our CLE today, because as we know, rules interact with each other and there is so much that happens within the rules. And so I just do want to flag that today we are going to be focusing specifically on the specific forms that work to initiate an action in the court. And the point of this exercise is to really do a bit of a deeper dive into the rules that relate to those forms and build some comfort with reviewing the rules and checking the rules and preparing the court documents. I should also point out, in case you haven't noticed, my computer doesn't actually have its own speaker or microphone, so I'm wearing a headset, which sadly died right before we started, on brand. Forgot to check to see if it was charged. So I'm actually tethered to my charging dock, and so there may be a mild disaster at some point. Don't worry about it. We'll figure through. So now that we have gone through, why we are here, I'm going to start with the ultimate civil procedure tip. Read the rules. You would not believe the number of times that lawyers may forget to read the rules to check to see if there are things that are impacting the procedure that brings them before the court. And so my rule for the rules is love the rules. Know which rules. Always, always, always double check the rules, because you may not know that if you don't look, that there's something that you've never run into before about the particular document that you are dealing with or your particular legal circumstance that may change a requirement that you've previously relied on. And you will note that rule number 2 is know which rules. So for the purposes of today's course, we are going to be talking about the rules of the Nunavut Court of Justice, which I refer to as the civil rules, because there, as we all know, there are multiple types of rules that apply when you are practicing with the Nunavut Court of Justice, because there are the civil rules, there are divorce rules, there are probate rules, the bankruptcy and insolvency rules put forward by under the Bankruptcy and Insolvency Act apply in Nunavut. And so if you just say rules, sometimes it can be confusing. So it's important to know which rules are applying when you are preparing a document, because each of the rules have different forms and different procedural requirements. But I will flag, because sometimes people forget, the rules default to the civil rules if there are not procedures set out in the specialized rules. So for example, there is a rule in the divorce rules that says if these rules don't say it, the civil rules apply. They don't actually use that terminology. I just use it because it's less confusing. Okay, so we are going to talk about the forms that are required for starting a civil action in the NCJ. Claire, why do you have a whole slide on that? That's why we're all here. I have a whole slide on this because this is subtle tip number one, people, because a number of the lawyers that practice in this jurisdiction practice in other jurisdictions as well. And it is not infrequently that sometimes counsel will forget and try to rely on a precedent or form that comes from another court's jurisdiction's rules. And so step number one is always, don't forget to make sure that you're using the Nunavut rules, that you're using Nunavut forms and Nunavut precedents, because it is a little bit awkward when we receive a form that is from a different court's jurisdiction or rules. So don't forget, because you've got a lot going on and sometimes you may forget. So what are we going to be talking about today? We're going to review the forms for a statement of claim. You'll see that I've put a statement of claim and then put form 1 and form 3. I'm not entirely clear on why form 1 and form 3 aren't one form, because you've got to file them together. So we're going to deal with them as one form today. We're going to talk about the petition form. And we're also going to talk about the originating notice form, which is form 4. And then, because you can also add a new claim, we're also going to be talking about form 8, the statement of defense and counterclaim. And again, don't forget, the rules can assist with determining which document to prepare. So, other thing to remember is that the sub rules, and fun fact, when you're referring to a specific rule or a specific subsection in the rule, they're referred to as sub rules. The sub rules work together like a dance, and it can be very tricky, and you can get tripped up if you miss a step, right? So this is why I'm a big fan of a belt and suspenders approach. I check the rules with regularity. And I will double check because I don't want to assume that there is something that I may not have missed the first time I've read them. Okay, so for me, a picture is worth 1,000 words. And I thought it would be very helpful if we actually dive into what the forms are and why the forms say particular things in referring to them. Because here's my second subtle thing. One of the reasons why I really love civil procedure is because the rules of court are basically the answer. There is very often not a question about how to do things that cannot be answered with a careful review of the rules of court. It's like having a cheat sheet for how to do things, but sometimes we have to do a little bit of work to try and figure out exactly what the rule is saying or what conventional practice is. So now I am going to try and change the screen that I am sharing. So we're just going to do a bit of a quick change here. Perhaps not so quick because I have to change my window, and we're going to change. So we're going to start with the. So can you guys see? It looks like you can. Okay. So is this how's the size on your screen of this document? Is this a good size for everybody? Do you want me to see if I can zoom in a little?
It's great. It's good.
It's
awesome.
Good. Yeah.
Okay. So what I have, thank you, Joy and Delaney. So what I have done is I have actually gone through the rules and in the red tried to highlight which rules apply to which parts of the form. So at the top of the form here, we're actually looking at form 3, which is the notice to defendants. So let's just have a little bit of a nerdy discussion right now, because Subrule 16.3 actually requires that the notice to defendants is served at the same time as your statement of claim. And we're going to talk in a few minutes about how the clerk issues the statement of claim, but really effectively, they're one form. You're not going to see these separately because you're required to deal with them both at the same time. So we're going to be talking about the statement of claim. It's down here. We're going to get to it. But in my mind, I treat these as one form. And why? Because of Subrule 16.3. Now, I am also assuming that you guys, if you would like, have a copy of the PDF, or if you're old school, which I legit appreciate, you have a printed copy of the rules. One of the tips that I always like to point out is on the court's website, under the rules where you find the rules, often people miss it because it's listed as a separate document. There is actually a table of contents and a table of forms that's on a separate PDF. There's some size limitations for how the documents can be put on the website, and I suspect that that's the reason why. But that table of contents is extremely helpful, as is the table of forms. So, and like legit, I have the only thing on my desktop, on my computer, are rules of court because I access them so much. Now, so Subrule 16.3, that's why we're starting with the notice to defendants, because you're required to have it. The rules also include specific requirements about what you are required to have on each pleading. Rule 15 is your friend. Know Rule 15. Highlight Rule 15. Rule 15 is why you have to make sure that you have a court file number on your documents. Things to check: that the court file number remains the same. These are things that the clerk's office checks, and that's for very good reason, because if you file a document and the court file number is wrong, it may inadvertently land in the wrong file, right? It likely won't, because the clerks are diligent to check these things, but worst case scenario, you want the court to know which file this document applies to. I don't know if you can see my mouse when I highlight around. Maybe I'll just try and do some highlighting. This part of the document is actually referred to as the general header. Make sure that you are checking that your general header is correct. Again, this is where sometimes we run into problems if we're practicing in multiple jurisdictions. Okay, there is no Supreme Court or Superior Court of Nunavut. It is the Nunavut Court of Justice. Subrule 15B requires that the style of cause, which is this part of the general heading, remain the same. That means you cannot change the style of cause unless there is a rule that allows you to do so. And we're going to be talking about some of those today. I can feel the excitement. So make sure that you have used the correct style of cause. Again, when we work in a world where we're using precedents that may get inadvertently updated, these are things that should be checked and double checked. In a statement of claim, the parties are referred to as the plaintiffs and the defendants. Something to check to make sure that you have referenced the parties correctly. The rules also require that documents and pleadings include a document title. And the document title is set out in the form for the particular rule, which is, in this case, Form 3. So in the notice to defendants, it is that rule why we refer to that, we make sure that this has the document title. Now, one of the things that sometimes people forget from time to time is that on the forms, the suggested language, the italicized language, that can be removed if you are not using it, or if you are filling out a blank, right? This part on the statement of claim, on the notice to defendants, is actually required by Rule 93. You are required to notify the defendant in the proceeding of the period of time prescribed by the rules for them to file a defense. And there are different rules. And again, here's the rabbit hole, people. That's the rabbit hole. We're not going to get into all of those rules today, but that's why you have to fill in this blank, Rule 93. They're required to provide a statement of defense, which is a separate form in the rules, Form 8, or an appearance, Form 7. Again, we're not talking about those today, but I wanted to highlight that look at how much on these documents are actually guided by the specific rules. So on your notice to defendants, now this is where it gets interesting in a admittedly fairly geeky way. The Rule 13 requires that the statement of claim be attached and served within 12 months from the day that this document is issued, right? That's Rule 13 acting right there. When we go down, this is a standard piece that is required to be on all originating documents. Rules 9 and 10 require that all originating documents, which are again defined in the rules as an originating notice, a statement of claim, or a petition, have to be issued by the clerk's office. Sometimes, from time to time, the court does see that lawyers file documents where this piece of the pleading has been removed. And that's a problem because Rule 9 and Rule 10 require the clerk to issue it. And if you provide a statement of claim that's not been issued, that's a problem. And again, we're not going to get into some of the deeper civil procedure issues about limitations of actions and timelines and things like that. We're here today to talk about forms, but it is extremely important to make sure that your pleading, when it's an originating document, includes this spot for where the clerk at the court is required to issue the document. So that is the notice to defendant in form 3. I'm going to go through the statement of claim. I don't see any current questions. Maybe we'll review the statement of claim and then open it up for discussion. But the statement of claim itself is in Form 1. Now, Form 1 is required because Subrule 8.1 requires that a statement of claim be in Form 1 under the rules of the NCJ. So that means if you try to file a statement of claim that is not in that form, you're probably going to have a bit of a discussion with the clerk's office about some of the problems. Now, fun fact, we've reviewed our general heading. We've reviewed the style of cause and why you're required to have the court file number. You'll see here the document title is changed to what this particular document is because we are required to do so on the basis of Subrule 15C. Now, okay, fun fact about Form 1 in the NCJ. Form 1 is actually silent on pleading the claim. But it is important for counsel to ensure that they are including the claim that they are making and the relief that they are requesting in the document. So the conventional practice in the NCJ is that the claim, the paragraphs that set out the claim, I'm pleading for damages, et cetera, et cetera, et cetera, is actually found at the bottom of the document. I flag this because some of our colleagues who practice primarily in, for example, Ontario or Prince Edward Island, the claim in those jurisdictions, in those forms, is actually found at the top of the form. Now, as I said, interestingly, the Form 1 in the NCJ doesn't specify where the manner of the claim. And so if your preferred preference is that the claim be at the top, I don't anticipate that would ever be rejected. We do see from time to time, particularly for people whose preference comes from other jurisdictions. They initiate the document with the claim and then go into the facts. But conventional practice in the NCJ is that the claim is after the facts that are being relied upon. Okay. I have also flagged on this form a very interesting rule that relates to requirements for a statement of claim that is found nowhere near Rule 16 and Rule 15, which is where we normally find information about the statement of claim. Oh, Claire, I guess that's why you put the slide about how all of the subrules are a dance that provide different rules and steps that you may want to, take the time to review. But subrule 47.2 actually requires that if you're serving a statement of claim outside of Nunavut without a court order, you have to set out the facts and specific provisions in support of such service. So please do take the time to review subrule 47.2 in the event that you're serving a document, serving a statement of claim outside of Nunavut, because spoiler alert, there are actually particular circumstances where that is permitted and particular circumstances where you actually have to seek leave of the court to serve outside of Nunavut. So once again, important to read the entirety of the rules. Now, one of the other rules that is very interesting is Rule 107. That rule actually requires that paragraphs in pleadings are consecutively numbered. And sometimes we do see pleadings where lawyers are not checking to make sure that their numbering is correct. And believe me, particularly if you are using Microsoft Word, I empathize with how challenging it can be to do a consecutively numbered bulleted list with numbers, but that is one of the procedural requirements of the rules. And perhaps now is a good time to point out that, did you know that subrule 731.1 actually requires that margins on documents in the NCJ are 3.1 centimeters to the left, so 3.1 centimeters on the left side, and 3.8 centimeters on the bottom. Now, this is one of those rules where, not going to lie to you, there's nobody in the registry that's like taking out a rule and checking rule in the sense of rulers and not rule in the sense of the rules of court. But there are differences. I don't know if you can see, there was no cool, fun way to do this on Zoom, but there is a very marginal, get it, I made that joke, marginal difference between the sizing. So, nobody is checking that one, but it is a good reminder for to make sure that your margins haven't gone too wide. If you are actually printing and binding a document, please do consider the 3.1 centimeters, because it does make, it's in anticipation that the binding on the document actually cuts into some of the words. So my intention following the training is to actually distribute these kind of annotated in red copies of the forms to everybody. And I don't want to I'm going to ruin the surprise. I actually have a originating document checklist that goes through some of the things that you might want to think about when filing an originating document that will also be circulated, because nobody loves a checklist more than Clare Cudmore and perhaps pilots. But so those will be circulated following the training. If that's helpful. Thank you for asking, Bruce. I should have mentioned that. So, and I will also point out, just because it makes my brain hurt just a little, sometimes the formatting in terms of centering and things like that is a little bit off on this document, because I added the references to the subrules, and I spent quite a bit of time trying to make it work, and then had to just step away from my Microsoft Word rage. So now, so I have noted on this document about how the use of the claim and even the headings is more of a conventional approach. Now, I will point out that using those headings and specifying the claim are important because they assist the court in being able to refer to the document. Sorry, I've inadvertently changed screens. There we go. Okay. So all rules that you should be thinking about. Also, fun fact, Rule 731, Subrule 7312 requires that documents filed in the NCJ are 1.5 spaced. So you should be 1.5 spacing all of your documents. Now, why do the rules say things like that? Part of that is because you want the judges to be able to read it. Now, there is another rule that actually allows you to file documents that are in 10-point font. Please don't listen to that rule. Please don't file 10-point font documents. Many of the judges would have difficulty, many people would have difficulty reading a document in 10-point font. And so the rules allow between 10-point and 12-point. 12-point, solid. Think about 13-point font, because again, you want the judge to be able to read clearly what you're saying. And so, don't go past 13, but 13 might be a sweet spot because it's so much easier to read. So you also, again, want to make sure that you're using consecutively numbered paragraphs. And because I didn't go through and make up a fake, maybe I should have done up a fake statement of claim. But if you are putting your claim at the front, the facts section would continue on that consecutive numbering. If your claim is at the bottom, it would continue on the consecutive number after your facts. Okay. Also, just a fun fact, there's some direction in the rules of court, which again, since we're focused on form and not content, that we're not going to get into, about the requirements for pleading facts and statements. We will get into it a little bit more in the next training about interlocutory practice. So one of the other things to note that sometimes from time to time falls off of people's precedents is Subrule 16.2 requires that you propose where you want the action tried. So you need to be specifying if you are requesting that the matter be heard in Nunavut at the Nunavut Justice Center, or if you are requesting that the matter be heard in a community at one of the circuit court locations. Okay. This section here is also required by Subrule 16.1. You are required to date and put the location of where your document was signed, if it was signed by a solicitor or agent. And, again, if this was being filed by a self-represented litigant, they would not include this piece, but you are required to ensure that you include that on your pleadings. Sometimes people forget, so double check about that part, because again, Subrule 16.1 tells you that this is required. Now, Subrule 15E also requires that you are including your name, address, telephone number. By convention, the court would also like your email address, just because that is how people communicate in today's world. But please don't forget to include that on your documents. Now, currently, there is a bit of a discussion. I don't know how many of you were able to attend the recent civil bench and bar, but there is some review happening because there is currently a judicial direction in place requiring that counsel sign documents and scan it and not use a digital signature. So like the Adobe digital signature because there is not consistency among the court currently about that requirement. So I put a little asterisk next to it because we're hoping that there may be some clarified direction from the court about the use of digital signatures and a definition of digital signatures on documents. And the court is aware, particularly for originating documents, that there is a PD that currently says that they are allowed, but just as a heads up, there is not consensus among the court. And so, please ensure that you are signing documents and scanning them. I will also just quick tip in case you have some challenges accessing a scanner. There is a free Adobe program that you can download on your smartphone called Adobe Scan, which is super awesome and very easily converts pictures into PDFs, so that you can print and sign and very easily have access to that process for free. I tell people because some people don't know about it, and I find it very helpful. Okay, so this, people, is when it's going to get a little controversial. Okay, so some of the pleadings, some of the originating document pleadings in the court include this section here, the to. If you were to eagle eye look at the Form 1 in the Rules of Court, you will note that this is not actually here. I have gone a little rogue with including the to here because subrule 16(1)(e) requires that the name of an address as it is known to the plaintiff is included in the pleading. Technically, the backer that's included with Form 1 indicates that it's required to put on the backer, but in practice that's challenging. One, for space reasons. Two, what if there's 34 defendants, right? We don't know. So convention practice says don't put it on your backer. Please don't put it on your backer. Please put as the to and list the name and address of each of the defendants on the statement of claim. So that is an acceptable conventional change. One, again, because you're not going to be able to fit all of the required information on the backer and the defendant's address. So that is a completely acceptable, encouraged practice. Now, if you want to file a backer that complies wholeheartedly with the form, it's not going to be rejected. It just won't necessarily be pretty, right? And then there's also the challenge of what if the address that you had for the defendant changes or is not correct? It just becomes challenging in terms of having to keep that up to date, etc. So one of the things I do also want to note in terms of things to think about that are surprisingly not formally required in the NCJ rules, the NCJ rules are actually silent on page numbers. I would suggest that it's good practice to consider, if you have a statement of claim that's going on to multiple pages, consider doing page numbers. And here's why. Much of the practice that happens in Nunavut involves counsel emailing scanned copies of documents to the registry, and they are printed. And if for various reasons, perhaps some people, I'm pointing to myself, are clumsy, if they're walking back from the printer and they trip and drop your documents, it's a little bit it's easier for them to recollate them if they're numbered. Right? It also is easier to refer the court to the page and the paragraph number. So consider using page numbers. Again, not required, but a little bit of a chef's kiss when we see page numbers on documents, because they continue to be helpful. Other thing to remember, because many people do not know, because it's different in other jurisdictions. The rules, Part 57 of the rules of the NCJ requires that all documents filed with the court are single-sided. So if you are sending documents or you are preparing and binding documents, note that they must be single-sided. It's not permissible to file print on both sides of the page in the NCJ. So just as a heads up, those documents will be returned to you and or marked as deficient, and the court will likely request that you refile the document. So don't forget, take off your standard save the trees double-sided feature, because it's not appropriate for court documents in Nunavut. So that's the body of the statement of claim. Note, we've got clear margins, we've got 1.5 spacing, we've made sure that we've signed, we've included our address, we've got the addresses for the defendant. We're now, getting a sense that we should know and love Rule 15 and Rule 16 because they apply quite a bit. Let's talk about the back sheet. Now, the back sheet is something that often the counsel may forget to file. The court, by convention, requires a back sheet on all documents that are filed with the court for multiple reasons. One of which is because the back sheet is the first place that the court checks to ensure that you have a valid roll number because you are a member of the Law Society of Nunavut, or you have appropriately reflected your restricted appearance certificate that says that you are licensed to practice law. Fun fact, Rule 17 in the rules requires that only lawyers who are in active practice in Nunavut are filing pleadings with the court. And we do check. We do speak with the Law Society and confirm both, especially if there is an RAC, we do confirm that the RAC is still valid. So your back sheet, again, includes the court file number. It includes the general heading. It includes your style of cause. Fun fact, sometimes people will include on the body of their statement of claim, in the general heading on the statement of claim, the correct style of cause, and then they will forget to update the precedent back sheet, and they will include an incorrect style of cause. Don't forget to check and double check that that information is the same. That also includes making sure that names are spelled correctly and that they are there consistently. You will note the references to the parties are included. All of this is required by Subrule 15B. We've got the document title included on the backer. And I thought I'll have to correct it. This one should say statement, notice to defendant and statement of claim. Not the end of the world if you just say statement of claim, because effectively they are treated as one document, but technically it should refer to both documents. So that's me. I had it there. I don't know what happened. I didn't double check before the presentation. See what happens when you don't double check things? Sometimes mistakes were made. You're also required to include your contact information and address. Again, your LSN roll number or RAC if that's appropriate. Which is also required for Practice Directive 45. Now, one of the things to note is that there are practice directives in addition to the rules that impact civil practice. So don't forget that you ought to be checking and knowledgeable about practice directives as well. One of the other issues that I wanted to highlight, because we often have questions, because the court requires an address for service for Nunavut, and often, not infrequently, counsel will challenge that and say, no, that's not required because they don't locate it within the rules. That is it is actually in the definitions in Rule 1 that says that an address for service is defined as an address for service in Nunavut. So you are required to put your address. You are also required to put your address for service if it is different. And the address for service does have to be from Nunavut. So that is an overview of the rules that work together to create the foundational requirements for a statement of claim and notice to defendants in the Nunavut Court of Justice. Does anybody have any questions or comments about the Form 1 and Form 3? If everybody talks all at the same time, just kidding. Okay, so if there are no questions, I'm going to flip over. I'm going to stop and then flip over. I'm sure there's a better way to do this, but we're just going to.
Claire, can I ask a question while you're flipping over?
Absolutely. You can ask a question anytime. They are encouraged.
So I put this in the chat, and it was just that whether the versions of the forms that have the annotations in red text that you've prepared, whether those are available for distribution or if those are just for your own reference.
So I prepared them for the purposes of training. It was my intention to send them out to the people who've attended, in addition to that the cheat sheet, the checklist that I've created to help review and prepare originating documents. If that's helpful.
Sure is. Thanks very much.
And hi, Claire.
No
It's Nalini. Also, there's another comment from Joey Murdoch Flowers in the chat boom, and also for the style cost from
yes, right. So the rules require and on some of the PDs it does say versus. Honestly, not a huge deal. You can use either. The Canadian practice is actually and the court is in the process of reviewing some of the practice directives and updating some of the forms. I suspect that in the coming time you will see an update to PD form 18A and see that the update is actually going to say and. So, but if you're filing a form that is in compliance with a practice directive, then that is completely acceptable. I do also thoroughly enjoy the level of detail catch. So thank you for raising that. Okay, so unless there's any more questions or thoughts on statements of claim and notice to defendants, which are two separate forms, but we are treating them as one. Okay, so next up, we have Form 2. Now, one of the beautiful things is that we've already done, I just want to confirm, you guys can see the petition now? Awesome. And if you want me to zoom in so things are bigger, please do just let me know. So the petition is something that we don't, lawyers, unless you're engaged in a fairly specific practice, you may not deal with petitions as much because there's a very limited number of actions other than divorce actions which actually deal with petitions. So petitions are actually required to be in Form 2, and you would see that Subrule 8.3 requires that a petition is used where it is required by the rules or an enactment. And so, you know, fun discussion. There's not a lot of enactments in Nunavut that require court proceedings by petition. So for example, under the Marriage Act, if you're petitioning for a declaration of death, you do that by way of petition. The Adoption Act, adoption proceedings happen by way of petition, and guardianship and trusteeship matters proceed by way of petition. Now, important to note that divorce matters also proceed by petition, but there are a separate set of rules about divorce, and they have their own petition. And so this form of petition is when you are relying on this, what I call the civil rules, and you would be referring to a divorce petition if you were dealing with a divorce. Fun fact, if you are engaging in a family law proceeding for someone who is not legally married, you would not use this form. So, you know, procedurally different approach. So a petition has different requirements than some of the other originating documents. And remember, all originating documents are pleadings, but not all pleadings are originating documents. It's like fingers and thumbs. So when you are using a petition as an originating document, the first question is, what allows me to proceed by way of petition? And you will note that the general heading on a petition is different than the general heading on a statement of claim. A petition actually requires that you state the act or other statute and the person in respect of whom the petition is being made in the general heading on the document. And I note for some of my colleagues that practice family law, there can be a little bit of dissonance, because from time to time we will see that somebody who is dealing with a divorce petition will use this general heading on the divorce petition, but fun fact, that general heading is not required under the divorce petition form. So, and just to also note, sometimes there are requirements in terms of the form themselves that are imported through the requirement of the form. So for example, there is no reference in the text of the rules to the use of this general heading, which states in the matter of, that is actually a requirement that is imported by reference in subrule 8.3 to requiring the use of this form. So that's why belt and suspenders, read the rules, but check the forms. And this is another thing where if you are practicing in another jurisdiction, the general heading requirement may differ. And I'm not going to lie to you, from time to time we see lawyers filing documents that say, for example, in the Supreme Court of Prince Edward Island, or in the Ontario Court of Justice, or I am blanking on the form of reference to some of the other courts, but please do check to make sure that your general header is correct. And then, similar to the requirements that we discussed for the statement of claim, the style of cause requirements are made by reference to subrule 15B. We've still got the requirement for the document title for subrule 15C, and you will see that the reason why those rules are in place is because Rule 18 makes these rules, some of the rules that apply, for example, under Rule 16, apply to all originating documents. So Rule 16 actually relates specifically to statements of claim, but then Rule 18 says, oh, by the way, some of the requirements of Rule 16 apply with variation to the all originating documents. So don't forget Rule 15, Rule 16, check and double check. Now, here are some fun practice tips that help your documents impress and be easier to read. So you will see on the petition form, there is a requirement that you are required to state the relief sought and the rules or enactment relied upon. People, a number of times, counsel are forgetting to actually include the relief and the grounds in this part of the document. We're also going to have that discussion, spoiler alert, during the next training about interlocutory practice, but don't forget, you're supposed to be specifying what you're asking the court for and what legal authority you are relying on to make that request. Now, pro tip. If you are claiming multiple relief, if you are relying upon multiple enactments or statutes, please consider setting out the relief and the enactments in consecutively lettered or numbered paragraphs, because it does make it easier for the court to read, and people, that's what we all want. We all want the judges to understand what we are advocating for and why we are advocating for it. And these things help. and it makes an excellent first impression. The next piece of the petition, and you will note that the other originating documents differ from the statement of claim in this regard. So on an originating document that is not a statement of claim, you are actually initiating an action by way of application. And sometimes there's a little bit of confusion because it's deemed to be an application, but you are actually making a motion, and the rules use those terms a little bit interchangeably. So from time to time in the forms, it can be a little bit confusing, but please make sure that you are seeking the chamber's date. And again, there is a helpful practice directive that sets out how to refer to a regular chamber's appearance, both at the Nunavut Justice Center or in a community. So please don't forget to check. But other thing, again, that's not specified in the rules, but just to let you know, by convention, the court is entirely open to matters proceeding by way of desk application, or sometimes referred to as a basket motion. So if you are filing a petition and effectively it's a joint petition, all of the parties agree that the relief ought to be granted, and you're seeking a consent order, you can actually indicate that you request the matter proceed in writing unless otherwise directed by the court. It's important that you're including as part of the requirement of the form where you want the matter to be heard and how you want the matter to be heard. And, separate discussion, not for today, but remember, the rules of court require that if a matter is going to take longer than 30 minutes, that is actually a special chambers appearance. So you may be requesting a regular chambers appearance, but if you request a regular chambers appearance, don't forget, that's not 30 minutes for you to talk on a contested matter. That's 15 minutes each. So if you believe that you can get that show complete between both sides or all sides within 30 minutes, that is properly a regular chambers appearance. But if you are seeking something that is going to take longer, where each of you may need more than 15 minutes, that is a special chambers appearance. And don't forget to refer to Practice Directive 33. Okay? But again, because it's not clear in the rules and it's not referenced on the form, you are allowed to request that the matter proceed in writing. It is where everyone agrees. It is an effective use of judicial time. And so don't forget, you're totally allowed to ask that. Okay? In a petition, you are required to proceed by way of affidavit evidence. The form requires that you set out the names of the affidavits that you are relying on. Now, there is a rule, and I'll make a note before I send this out. I'll update it to reference the rule, but petitions referenced with originating documents have to be served 10 days before the appearance. So this does not mean that you have to have your petitions prepared, but you do have to indicate what, I said petitions, I meant affidavits, but you do have to indicate from whom the court can expect affidavit evidence. Now, if you have not signed up for the training on interlocutory proceedings, we are going to be going into more depth on affidavits, and it will be thrilling, and I highly encourage you to attend. But note, as a conventional, where it's just like tips for things that make judicial lives easier and advocacy clearer, I've put suggested hints and tips in red. But again, it is very challenging to read. If you're expecting 7 affidavits, it's very challenging to read when it's just affidavit, comma, affidavit, comma, affidavit, comma, and a huge paragraph. So do consider changing it to say that in support of the petition will be read the following affidavits, copies of which are served with this petition, and then list the affidavits with consecutive letters or numbers. At that stage, after you've listed your affidavits, that's where the facts are listed. And again, Rule 107 requires that the paragraphs are consecutively numbered. Okay, so don't forget to check those numbers, and also to check your formatting. Like how you're presenting the information, the court notices, the court comments sometimes, you know, at not necessarily negatively, but certainly if someone's claim is presented or their petition is presented in a way that's really easy to read, I will tell you, the judges comment, staff comment that it is clear and easy to read. So again, first impressions. We're going to come back to Subrule 16.1 applies. You do have to indicate that it's dated and that it's delivered by the solicitor or agent. That requirement is imported into all of the originating documents. Again, same requirement to include your address, phone number, etc. from Subrule 15E. Again, we've already talked about Rule 9 and 10. Don't forget to check to make sure that you have included the spot where the clerk has to issue it. Because again, and that's a great example of how effective civil procedure actually impacts the timeliness of access to justice. Because if we have to send that back to you because you've forgotten to take it off, right? That's time, and time is money, people. Particularly when you're billing in 6-minute increments. So please don't forget to double check before you send it in. Again, we've been a little cheeky, and I'm suggesting that it's better practice to include the two, and this is actually on the petition form, which is helpful, but you do need to include the addresses for each person that's required to be served. And I will note, and this applies to the general heading as well, don't forget to check to make sure that you are referencing the parties appropriately. By that I mean, because it's natural, right? Sometimes you are taking a precedent and you've got your style of cause and you're just copying it from one document to another. Don't forget to check that on a petition it says petitioner and not plaintiff, because sometimes people do forget. And it's important that the court knows which party is what. Like I have seen, we had some challenges with a document in the past because it was clear that the lawyer was using a precedent. And at one point, the document referred to a plaintiff. At another point, it referred to a petitioner. At another point, it appeared to be referring to the respondent, but actually was referring to the moving party. And it was, like, with the greatest respect, we were unable to comprehend which party the person was referring to. And that's not a great position for the court to be in when looking at your documents. And I fully understand when you're looking at preparing documents, you're not looking at one thing, right? You've got 18 things going on, but it is an important reminder to slow down and take the time to look at the documents that you're preparing, okay? So you will see that the back sheet is very similar to the statement of claim, but the general header has been changed. Now, some of you with eagle eyes may have noticed my backer is not 1.5 double spaced on a petition. I don't know how you would get all of the information required in that general heading on a petition on a back sheet on one page. So I would play with the formatting a little bit on the back sheet to try and get it on one page, because it's less helpful if it's on more than one. Okay, so don't do that generally, but if you need to condense things a little bit to get it all on one page for a back sheet, it's not going to be rejected. We just want the information to be there. But I am going to point out, and I'm going to sound a little cheeky. I don't mean it cheeky. Sometimes I think I'm hilarious. It's called a back sheet, people, because it's supposed to be on the back of your documents. You would not believe the number of times that people will, particularly with documents like affidavits or like a lengthier statement of claim, people will put the backsheet on the second page of the document. So please just don't forget the backsheet is on the back. Like if you have an affidavit that has exhibits, the backsheet is not after the signature line of the affiant. The backsheet is after the last exhibit. And again, the interlocutory proceedings training is going to be a hoot, and I hope you all come. Yes, I do love civil procedure this much. I can hear it. I can't stop it. I just love it. So that's the discussion. Backsheets. So great question. I see, and you're very welcome. I'm so happy to help. I love talking about civil procedure, Victoria. So, and just because I don't want to make assumptions about people's gender preferences, I hope you don't mind if I refer to you by your first names. And also because some of you have some really beautiful last names that I don't want to mispronounce. So backsheets, there's nothing that says that a backsheet can't be more than one page, is the answer to that question. That's the beauty of the rules. There's no rule. I mean, full disclosure, there is actually no rule that requires a backsheet on every document. That is a judicial direction and a conventional practice. So in other jurisdictions, there's rules that specify that a backsheet must be included on each document. But fun fact, not actually found in the rules of civil procedure in the NCJ. So so that is very, very important to remember. It's not in the rules, but it is a conventional practice. So please don't forget your backsheet. Also, because full disclosure, the judges like backsheets. They find them helpful. So if the judge likes it, take the time to do it. Generally is a good procedural practice. So we haven't actually discussed costs yet. Keith, did you want to jump in with a question?
Yeah, I do. Thanks. So I'm just wondering, how can a person who's filing a statement of claim, because there's usually like a filing fee. So what are the methods that they could pay? Because I ran into this issue when I was a legal aid counsel, and as legal aid counsel, we didn't have to pay filing fees, so that wasn't a problem. But then when legal aid decided not to take the case, the person had to file, and it was a time sensitive matter. But then I think the court at the time wasn't taking like Visa over the phone or something like that. It had to be like a check or cash or something like that that required some kind of personal attendance. So I'm just wondering if you could refresh us on filing fees and how they may be paid. Thanks.
So great question. So filing fees are actually payable in a number of ways. And I will also point out that there is authority under the court fees regulations and the Judicature Act for court fees to be waived if there is hardship. So if you were to go to the Nunavut Court of Justice website under rules, fees, and policies, there is in the fees and policies section at the very bottom. It's a long answer to a short question, Keith, I'm sorry. But at the very bottom, there is a civil registry filing form. And if people contact the civil registry, there's a process by which you can actually get set up to pay to pay through the sheriff's office. And I believe, and I apologize, I wasn't actually here during COVID, but the payment over the phone is, I believe, available now. But if anybody ever has questions about how they can pay, they should contact the registry, and happy to clarify. And if there's issues or you're not sure who in the registry, throw me an email and I can help navigate that issue. I'm always happy to help. But I will point out, if there is like a challenge with affecting the filing fee, that's certainly, particularly where it's Joey, I that joke, it follows me around. I don't say it intentionally, but yes, we're going to clarify. If there are challenges, like the court is committed to access to justice, and certainly if there's a limitation period involved, that's something that certainly should be communicated in terms of the need to file the document and sort out the filing fee later. If that answers your question. Thumbs up. Okay, so I'm just cognizant of the time, and technically we only have 15 minutes left. So I also have the originating notice, which I'm going to quickly bring up. Much of the originating documents are very similar in terms of the application of rules 15, 16, 18, rule 107, rule 731. All of that magic happens on all of the originating documents, but I'm just going to pull up the originating notice because there is actually a fundamental, not huge, but important distinction when preparing an originating notice. So, sorry, I'm just trying to bring up the window. Originating notice. So you'll see that the originating notice, if you can all see it well, is similar in terms of the contents of the form and the suggestion that you're going to use like bulleted lists and things like that. But again, similar to what we talked about with the petition, remember that when you are filing an originating notice, you're filing that notice to request to make a motion before the court. And again, you can ask to do that by way of desk application. So if you need to, don't forget, because the court needs to know how you want the matter heard. Don't let that part fall off, but you can include that desk application piece. And again, we've got those tips in rule 9 and 10. I'm pointing at my computer like you can see it. Okay, so, but here's what I want to talk about. The back sheet on the originating notice. So the originating notice is actually the only other reference to a back sheet in the rules. So and it is actually referenced as a requirement on the form that you include this notice to respondent on the back sheet. And the form of the originating notice form actually includes, you need to include this notice to the respondents on the back sheet. So if you are filing an originating notice and you are using a precedent of a back sheet from a petition or a statement of claim or an affidavit, this piece here is not going to be included. And you need to make sure that the respondents are notified that they have to respond. And so don't forget to include that piece. It is a requirement, and it is on just as a small kind of paragraph in italics at the bottom of the form, which, guys, is a really good reason why it's important to check and double check the forms. Don't just check the rules, review the form before you do it. And again, I have once again am suggesting that you would actually depart from one of the requirements on the back sheet of including the addresses for the defendant on the back sheet, because then it's going to be like 17 pages if you're engaging in litigation with 17 people. So you will see that we've included that too on this form. Okay. So I will also, if people don't mind, like a quick run through, I'm just going to bring up the statement of defense and counterclaim. Nope, wrong one. Here we go. Okay, so the statement of defense and counterclaim is Form 8. There are additional rules that apply to the counterclaim process, and it is important that you take the time to look at them. So for example, remember throughout this discussion, we've been talking about the requirements in Rule 15 about keeping your style of cause safe. Fun fact, you can actually change your style of cause in particular circumstances, and filing a counterclaim where you have added additional defendants is one of them. So subrules 95(7) and 96 sub 1 allow you to add defendants if they are defendants by way of counterclaim. So that is one of the times that you are going to be changing the style of cause. And my polite suggestion, because the civil registry does check to make sure that style of causes are consistent and that court file numbers are the same. So if you are filing a counterclaim or you are filing any document in the court where you have changed the style of cause, and remember, the style of cause is the reference to the parties in the proceedings. The general heading is that top piece that says in the Nunavut Court of Justice and the court file number and all that jazz. So if you are changing that style of cause or you're changing the general heading on a document, because you are allowed to do so, because there is a rule like rule subrule 95(6) that says that you can, when you email the document to the registry, I highly suggest that you say, please note, I have stated that the style of cause has been changed in accordance with subrule 95(6). Let me just go through the rest of the document, Greg, and then we'll chat about that if that's okay. I'm just cognizant that some people may need to leave, and I'm happy to chat until, like, what a better way to spend a Friday afternoon than discussing civil procedure in the Nunavut Court of Justice. So let me just go through the rest of the counterclaim differences real quick, if that's okay. So that rule is important to remember. Also remember that subrule 95(5) requires that counterclaims are filed as part of your statement of defense. There is no separate counterclaim document. And so the form includes the both pieces of the document. But if you're not making a counterclaim, you would just remove those portions of the document. Okay? So but you could not then file a separate counterclaim in the same proceeding because of subrule 95(5). Now, again, separate continuing consecutive paragraphs. And fun fact, we talked during the portion about statement of claims that there is actually no reference specifically in the rules about how to include the claim, which is referred to as a prayer for relief, as in, please let me have what I'm asking for. But on Form 8, which is the statement of defense and counterclaim form, it says the prayer for relief should be in the same form as the statement of claim. So take from that what you will, but I would suggest that, there's no specific direction as to what the form of the counterclaim is, but if you are responding with a counterclaim and the statement of claim has the claim at the top before the facts, you may want to, if you are adding additional facts that set out the grounds for the counterclaim, you would claim at the top if it is on the statement of claim at the top, if you were following that to the letter. But again, court, the registry is not going to reject your documents if the claim is at the bottom and the statement of claim is at the top of the counterclaim, on the counterclaim document. So those are substantively the difference between the originating kind of counterclaim portion of the statement of defense. You'll also note that there is no requirement in the rules for a notice of defendant, a notice to defendant on a counterclaim, perhaps because the intention is that you're serving the person who has been dealt with. And if you're adding someone, there's a whole separate procedure. So there was a question about, Greg, do you mind if I just switch really quickly to the last part of the presentation? And I'm just cognizant of the time. Is that okay? I've got about 3 minutes. Okay. So just going to switch back to window. Oh my goodness, hurry up. Here we go. So, so I pop back to Zoom and then switch to the window. Okay, so important tips. Make sure you have your rules handy. This is a live screen of what my desktop looks like. All of the documents, all the PDF documents on the left here are rules. They are infinitely accessible to me. I open them all the time. I have them like annotated with my own notes and things like that. Don't rush. Take the time to check and double check your documents. I do have a fun kind of things to think about checklist when preparing originating documents that I'll be sending out with the annotated in red helpful tips about the rules that apply and things like that. And remember, if the registry sends you a document back and it's not stamped or rejected, it's a sign that there's some issues that you may want to correct. We do have a helpful, everybody knows that I talk about this tip sheet all the time, but we do have a helpful tip sheet on how not to have your documents returned. Know it, love it, check your documents against it, right? And so if you are doing something, also be prepared that the registry is going to ask you what authority are you asking us to do this for? So just feel comfortable knowing which rule allows you to do what you are trying to do. Be comfortable knowing which rules say that this is how you are to present your document, okay? Now, I have included what I think is a funny joke about the use of Word, because I'm not going to lie to you, it was a slightly frustrating exercise to try and add the red to all of the documents. So we understand and we empathize that from time to time, things can go a little sideways. Don't take it personally if the registry returns documents and gives you the opportunity to correct them, because we all make mistakes. And sometimes there's going to be situations where there's a rule that you forgot existed because you use it once every 3 years. So that is our fun review of the forms that relate to initiating actions in the Nunavut Court of Justice. So Keith, if anybody has any questions and they want to, Christine, thumbs up to a fellow Whovian. But Greg, you had a question, and you guys, I will sit and chat with you guys for the rest of the afternoon if you have questions or you want to talk about civil procedures. Thank you, Joy. I hope that this series is practical and helpful, and also just a good reminder that the rules are there to help you. The rules have all of the answers or opportunities for some really interesting debate. Don't forget to check the rules. Don't forget to look at the forms. Greg, you had a question.
Hi, yeah, and first of all, I'll say definitely thank you for putting on not just this session, but there's a few coming up that I've got just for her CLE requirements. Joanne Smith's here with me as well.
Heyo.
Joanne. That's a good point,
no,
ladies and gentlemen. If you are sharing a screen with somebody, please do let us know, because it all counts.
But yeah, I'll say thank you very much for putting this on. Looking forward to the future ones. The question was in relation to originating notice. In our particular context, we're particularly concerned with family law applications. Is there a need to file a separate notice of motion if you're filing an originating notice? Obviously, you need to file an affidavit with it. Yeah, those are. Is there a separate one that's also required? We've been doing so just to make sure it gets on the docket, for example, but that may be unnecessary. We want to clarify.
So that's a fun question. So when you're filing the originating notice, you're filing the originating notice and including which affidavits you're going to rely on. You're including which relief you're going to be requesting in accordance with the proceeding. And so you're seeking a court date. The originating notice is in itself a motion. And so I will clarify to court whether or not they want a subsequent notice of motion, but generally you would only be filing a notice of motion if there was some interim or interlocutory relief that you wanted in advance of the originating matter proceeding. So for example, if you were seeking a final determination on parenting time and decision making in the originating notice, but you've set that, you've requested a date that's sometime down the road, or you've requested that matter be adjourned sine die while the parties try to resolve issues or prepare information, you may be in a position where you want to file an interlocutory motion by way of a notice of motion to seek interim or interlocutory relief. So I guess the answer to the question is twofold. One, let me confirm what the court's preferences are, because that would be my expectation based on the rules. But sometimes courts have conventional practices. So let me just check and make sure that what I'm saying is actually correct. And then I'll send out a email to the group. But those are the types of like practical procedural issues where there's a convention that you're not sure of. You're welcome to email myself to ask to get clarification from the court. I'm almost, in the literal sense, always happy to talk procedural issues. Part of the challenge with my role is I can't provide specific advice about how to proceed with a specific legal matter. I can have a general discussion with you about procedure, or I can seek direction from the court about a conventional process. Absolutely happy to chat. So I will clarify that.
Thanks, Claire. Really appreciate it.
Anytime. Any other questions?
Third-party claims, or is there a possibility to start a third-party claim in Nunavut?
Yes, so there is, if you were to refer to the rules of court, there is actually a third-party claim process, and the third-party claim, sorry, I'm scrolling in my rules. Ding, 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 originating notice, appearance, statement of defense, third-party notice is Form 9 and required under subrule 142.2. So I would again, civil procedure, a rabbit hole, right? Yeah. There's so much stuff that we could talk about. But the lesson that I hope that people like take in from the series that we're doing is check the rules, know the rules. I personally have the rules on my desktop and such that I can the Control F is your friend, right? Search the word third-party notice in the rules and it will take you to the various points. Again, the table of contents is so helpful, and a number of council don't know it exists because of how it's put on our website. And so please make sure that you are checking. The Legislative Council Office actually updated and consolidated the rules of court. And we are hoping there was a minor technical issue with the territorial printer. So there were some challenges with how the forms were included in the update. So we haven't spread that wide yet until those are, that the opportunity is taken to update those. But if you were to go to nunavutlegislation.ca, because the rules of court, fun fact, are treated as a regulation in accordance with the Legislation Act, and they are a regulation to the Judicature Act. And so if you were to go to nunavutlegislation.com and bring up the Judicature Act and its accompanying regulations, you will see that the Legislative Counsel Office has done a beautiful job of updating the rules so they refer to the Nunavut Court of Justice, but they are also more easier to read in terms of formatting, because the English copy is on one section and then the French copy is at the bottom. One of the challenges just practically with the current, no longer current, but old rules, is that the forms, I find it just a little bit, it takes additional time because the forms are presented so that there's first page in English, first page in French, second page in English, second page in French. And so the new updated consolidated rules are beautiful. And the only reason why I don't refer to them more is just because there's some challenges with the forms, and this CLE was about the forms. So I expect that those are going to be updated soon, and you'll have a beautiful new copy of the rules of court that you can put on your desktop and refer to regularly. Any other questions? Okay, well, thank you so much. Again, I do note and so appreciate, because family law is one of the areas I love, the number of family lawyers that are here. All of these lessons and references you can use by reference to how you're dealing with the forms under the divorce rules. So don't forget to look at, why the divorce rule forms have particular requirements, and checking the forms and the rules, the belt and suspenders approach. Thank you so much for coming, everybody.
Thanks so much, Claire.
Awesome. Have a good weekend. Thank you, Nalini.
Thank you. Thanks for everyone.